A right is fundamental against the states if it is essential to an Anglo-American scheme, not some scheme of ordered liberty where you can hypothesize all sorts of cultures, but rather within the American tradition or the American conception of what we regard as a free society. Is the purported right one that is essential to that kind of scheme of ordered liberty? And the sole criterion that you use to determine whether it is whether it is deeply rooted in American history and tradition. Now, that has clear implications for other rights, such as, for example, is there a right to marriage between a man and woman? Well, that certainly satisfies that criterion. But the right to marry someone of the same sex, or the right to marry more than one person? Well, there would be societies for that latter one, for polygamy. There would be other cultures where that's in fact the case. In fact, out of 192 nations around the world, about 50 of them actually have polygamy and have had it for centuries. But in terms of homosexual marriage, that's something that was first invented on the planet a little more than a decade ago and is less than a decade old in this country. And so, people can say it should be legal, people should say it should be illegal, but you are really just creating you are rewriting the doctrine of fundamental rights if you want to suggest that somehow when the 14th Amendment was adopted, this was some fundamental liberty interest that was thereby secured in it. So, and that issue will no doubt be before the Supreme Court soon enough. It was almost before it last year, in fact. But that theory of selective incorporation, as it's called, was thoroughly rejected by Hugo Black. And in 1947, that was in the early years of this debate. So really, Justice Black just said that the First Amendment is incorporated to the states through the 14th Amendment. Doesn't really specify whether we're talking about the Privileges or Immunities Clause or the Due Process Clause. Those subsequently, of course, through the theory of substantive due process, that is where now all of the eggs are put in that basket. But it's he just kind of said in a broad-based fashion that it was, without any real discussion. I mean, there was a little bit, but no thorough discussion as to whether and why this was some sort of a fundamental right. But nonetheless, the court in Everson incorporated the Establishment Clause against the states. Before 1947, a state could say, we are a Roman Catholic state. We are a Southern Baptist state. We are an Orthodox Jewish state. They have the latitude to do that. Now, as a matter of realpolitik, they didn't do it. There were states that had religious establishments, but early in the 1800s, those were just done away with democratically. But the other thing that the court did in Everson, the other part of its holding, was in saying that the Establishment Clause requires a principle of neutrality on matters of religion. Now, that is the first time that the court adopted, from a letter by Thomas Jefferson to the Danbury Baptists, adopted the phrase that there is a wall of separation between church and state. Now, that has been, it's a very unfortunate metaphor. It should be noted, by the way, that Jefferson was one of the three most secular of the major founding fathers, the other being Benjamin Franklin and James Madison. Also, that Jefferson, at the time the Bill of Rights was adopted, was Secretary of State and was not actually directly involved with the writing or proposal of the Bill of Rights, including the Establishment Clause. But nonetheless, that letter was adopted by Hugo Black in his decision declaring this principle of neutrality. The government should be neutral between religions and with regards to religion generally. Now, the religious people in Everson, it had to do with the transportation costs of children to Catholic schools. The religious people in 1947 actually won. Now, under the modern version of how that rule is applied, it's quite questionable as to which way the court would have come out. So even in using that metaphor and that language, the court did not mean in 1947 what people say it meant afterwards. However, I would say that Chief Justice Rehnquist, he was Justice Rehnquist at that time, and Wallace v. Jaffrey got it right when he said that the Establishment Clause has been freighted by that metaphor ever since it was adopted, and that it is based on bad history and worse law, and ought to be explicitly, frankly, abandoned But nonetheless, it's on the books right now, and I'm also not sure there are going to be 5 votes to overrule it anytime soon. Now, after Everson, you saw the rise of 2 schools of thought regarding the Establishment Clause. Now, one, I shouldn't say the first one didn't arise, it was the pre-existing school that continued, and that was what's called accommodation. Now, an accommodationist believes in this. In fact, you should look at Zorich v. Clausen, 1952, where the court, written by a liberal justice, actually, Justice Douglas, where the court discusses that the American people are a religious people whose institutions presuppose a supreme being, and that when the government takes measures to benevolently accommodate the religious sensibilities and priorities and holidays and special events, etc., of its citizens, that the government is following the best of its traditions during that time. Now, accommodationism is the part of the historical standing of the Establishment Clause. Now, that is in contradistinction to the school of thought that started to arise in 1962 and 63, and that is strict separationism. Strict separationists believe that the Establishment Clause, always citing to this wall of separation between church and state, that it is designed to wall off every area of public life, the public square and other aspects of public life, from matters that touch upon the religious. That it is a mandate for a purely secular public square in public life. And you started that with Engel v. Vitale, which outlawed prayer in school. And then the following year, Abington Township v. Shep, which outlawed mandatory Bible reading in school. Now, that was the beginning of a series of cases in the 1960s where you saw long-standing expressions of faith struck down for violating the Establishment Clause. This was essentially unprecedented in American history. It reached its high point, what I would call its worst point, in 1968. Now, 1968 was the most liberal year in all of U.S. Supreme Court history. That was the height of the Warren Court. After LBJ had appointed everyone he was going to appoint to the Supreme Court, but before Richard Nixon became president and started to swing the court back towards the middle, started swinging it towards the right. And in 1968, you have a whole host of what I would call just profoundly incorrect decisions. 2 of them had to do with the Establishment Clause. One of them was Flass v. Cohen, which made this anomalous sui generis exception to the rule against taxpayer standing for lawsuits that allege an Establishment Clause violation. Now, the court in Flass, cites some history, and from that they say that implicitly the Establishment Clause was inter alia. Now, you're in law school, I just said inter alia in conversation. That the Establishment Clause inter alia is a spending limitation upon the legislature. And therefore, whenever taxpayer money is being spent in support of religion, that it is possible for a taxpayer to have Article 3 standing to sue in federal court, which, for any of you who are no longer 1Ls would know, is never the case for any other provision under the Constitution. Now, the court allowed that there could be some nexus, etc. It created a 2-part test to determine whether or not there's taxpayer standing, but conveniently nothing aside from the Establishment Clause qualifies. Now, the court has tried to walk back ever since it was handed down, Flass. Several justices always say we should overrule it. In modern terms, that's always Justice Thomas and Justice Scalia who say that. But nonetheless, you have the issues of stare decisis. You just don't get 5 votes to that point. The modern doctrine regarding the Establishment Clause taxpayer standing exception is Hein v. Freedom from Religion Foundation, 2007, where the court, in a plurality opinion, no majority, conveniently, and symptomatic of the rest of the Establishment Clause, but nonetheless, the court rule is that in order to have standing to sue as a taxpayer, you must show an itemized line in legislative appropriations, either congressional appropriations or state or local legislative appropriations. An itemized line in the budget, in the appropriations legislation, that specifies funding for the specific religious matter. That is to say, if the legislature merely appropriates some general funding for something, and then someone in the executive branch earmarks some of that money for religious purposes and spends it, that spending doesn't give anyone standing. It is only the legislator's act of appropriating that money to hand it to the executive branch. That and that alone is what can trigger standing. Now, if that seems kind of like an odd line, that's because it is. It seems counterintuitive, but there's nothing counterintuitive in law. I mean, everything in the law perfectly makes sense. Like the rule against perpetuities. You could sit around and natural law reveals the rule against perpetuity. But that's what you have when you don't have 5 votes to overrule Flast. The other case that was the big mistake out of 1968 was Epperson v. Arkansas, where the court took an aspect of Epperson, which some would say is dicta. I don't know if it was or not. Doesn't really look like dicta, but it might have been. But the court either reaffirmed as a holding or elevated to a holding part of Epperson, the part that says that government cannot prefer religious faith generally over irreligion, over non-belief, over atheism. Now that would be something that would be astounding to the Founding Fathers. It's George Washington in his farewell address. George Washington, again, one of the more secular among the founders. He didn't wear religious faith on his sleeve the way many of the founders did. In fact, a great many of the founders had seminary degrees. Many of them were in ministry. Roughly half of those who signed the Declaration of Independence, in fact. George Washington, in his farewell address, singled out for special attention that he said that in vain would people try to make their society succeed without what he called the twin great pillars of society, morality and religion. And that he saw one as arising from the other. And that he said that both of those were necessary and essential supports, both for civic happiness and for prosperity. Now that's where you get into the public good associated with religious faith, a matter of teaching people that they should be honest, they should not steal, to inculcate them at an early age with the idea that there is such a thing as absolute truth, that their personal conduct and family affairs and business affairs should be structured accordingly, that they should be people of integrity, that they should not lie, that they should keep their commitments, that they should respect the property rights of others, that they should respect their own contractual obligations, that they should be mindful of the criminal law, that they should regard themselves as under the watchful eye of an almighty creator who sees everything and knows everything, that you can't get away with stuff, that there is justice either in this life or the next, and that all of those principles should inform people's behavior at an individual level. It should dictate how they act as a citizen, how they act as a family member, and how they act as they engage in commerce. And that if a critical mass of the people voluntarily adhering to these principles, having sensitive consciences to these things, leads to economic prosperity. It leads to people working hard, being mindful of the future, not just frittering their money away on wasteless pursuits, on taking care of themselves and their families and of those in need. And that if you get a critical mass of people that do that, it causes society to flourish. So Washington cited that in his farewell address. His successor, John Adams, said that the American Constitution was written for a religious and moral people, and that it was wholly inadequate for any other. Now, Adams kind of gets short shrift in the scene of our founding fathers. He was our first one-term president, and I think people tend to write him off as a result. The reality is this. We probably would not have had the votes to declare independence from Great Britain were it not for John Adams' lobbying efforts. And then Adams, who was regarded as one of the finest lawyers among the Founding Fathers, was really a formative influence in terms of the structure of the Constitution, though ironically Adams himself was first an ambassador to France and was an ambassador to Britain, and so just as Thomas Jefferson was gone for much of that time. And so they weren't actually in the room as much of that was being decided. But nonetheless, their writings, if you read back, Adams actually did a work years earlier, which speaks about the separation of powers, etc., a system of checks and balances, and those principles were actually incorporated into the final structure of the Constitution. He might not have been arguing it on the floor of the Constitutional Convention, but everyone there had seen his stuff. And so these were the things that were discussed during that time. And of course, Adams did then become the second president and appointed a great many Supreme Court justices, including John Marshall, and established much of the doctrine that was foundational to the role of the judiciary in the Republic. So Adams says that. And then you have Thomas Jefferson. And in Jefferson, as secular as he was, in terms of the administration of the Northwest Ordinance, which had been originally passed under the Articles of Confederation, but was repassed under the Constitution, which spoke about the need for the teaching of morality in public schools. So those sentiments, those don't just belong from days of yore. They come up as recently as I would commend to you to just look up the text of President Ronald Reagan in his speech to the religious broadcasters. You would have thought you were listening to a sermon, and from olden days. It's not something we've gotten so used to secular language from our heads of state that people would be shocked to see that just a quarter century ago you would have a president who said that Americans need religion. Because it's religion that informs our consciences, that gives us a sense of morality, and that he says it is religion which gives people the humility to acknowledge they don't have all the answers, to feel accountable for their actions, for their consciences to be prodded. And he goes on to say, if we ever forget that we're one nation under God, then we will be a nation gone under. Now, said today, many in the media would scream theocracy, and what is going on? Oh my goodness. But nonetheless, that is what we had in our heads of state up through the 1980s, long past Everson. People look to FDR as the progenitor of the modern establishment, of the modern administrative state. Good grief, when we were invading Normandy, FDR led the American people on national radio for more than 10 minutes in a prayer, asked the American people to pray with him, and he prayed, and he prayed, and he kept on praying. Again, where you would have, I think if that were to happen now, a host at MSNBC would openly weep, gnash their teeth on camera. But nonetheless, that was standard fare for the vast majority of our existence. But according to the court after Epperson, you really couldn't allow that. So after 1968, you appear to have these conflicting lines of cases. You had accommodationist cases, and you had strict separationism. So in 1971, the Supreme Court decided to try and splice this all together and create a general framework for the Establishment Clause. And thus we got the Lemon Test. An unfortunate name which has lent itself to all sorts of metaphors. It's can you make lemonade out of lemon? Boy, we really got sold a lemon. Law professors think they're funny when they say those things. And in terms of really dense, dull, scholarly literature, it is nice to sometimes see something that is at least a half-hearted attempt at humor, regardless of how bad of a sense of humor the author happens to have. But nonetheless, in 1971, regarding a statute that allowed for supplemental income for public school teachers, for private school teachers, so long as they were teaching secular subjects, etc. The court developed what was called the Lemon Test in Lemon v. Kurtzman. It is a three-part test. It is that when government action touches upon religion, it violates the Establishment Clause, unless, 1, it has a secular purpose, 2, its effect neither advances nor inhibits religion, and 3, it does not excessively entangle religion. Now, all of that has been tweaked over time. Now the purpose prong is it must have a predominantly secular purpose. But I'll tell you, that test was an unmitigated train wreck from the day it was handed down. Because first of all, a predominantly secular purpose. Well, obviously, there is a purpose whenever legislators write something and vote upon it. Now, if it is a matter that touches upon the religious, then it seems implicit that there is some sort of religious motivation there. However, one would also think that at least often, not always, but often, there is some sort of secular purpose, some sort of general public purpose that lawmakers thought they were advancing when they enacted whatever the legislation is. So the first problem, well, that's completely unworkable. How do you determine whether the religious purposes predominated over the secular purposes? How do you poll the lawmaking body and have some sort of metric to assess what their priorities were and how much stronger one was by the other, and whether or not a majority of the legislators actually were voting upon a secular reason that in their personal minds happened to be trumping the religious reasons? Judges just aren't equipped to read minds. We just hope they can read law. The second prong, it must have an effect, the effects prong. It can neither advance nor inhibit religion. Well, first of all, you can ignore the second half of that. Nothing has ever been struck down for having the effect of inhibiting religion. In fact, government action inhibits religion all the time. You never see the Southern Baptists file suit and win, getting a judge to strike down some program that actually stands in the way of religion in that regard. So the effects prong has always been about whether the action advances religion. Well, that too is unworkable, because the fact that you have an Establishment Clause lawsuit means that something in the public sphere is in fact doing something with religion. Well, isn't it almost ipso facto that to some degree that is advancing religion? I mean, how does the government touch upon religion and not in any way, touch upon religion, put it in the public square, and yet not somehow be advancing religion? It really opens the door. In fact, it takes real creative thinking from a judge to figure out how it would not advance religion. So again, that becomes, where do you draw the line there? Because really, it would touch upon almost anything. I mean, even the national motto, "In God We Trust." Well, that appears to be advancing, the idea that A, God exists, and second, we trusted Him. Who is the we? Well, it's on our currency. Well, it must be the American people. My goodness, did we just declare that the American people trust in God? And there's a question about whether that advances religious faith? So the advancement problem, the effects problem, another problem. Then you have the entanglement problem, whether it excessively entangles government with religion. Not whether it entangles, but whether it excessively entangles. How does a judge figure that out? I mean, the reality becomes this. If you are a more liberal or secular judge, whenever you see the entanglement, you say it's excessive. If you're a more conservative judge, maybe one who's more comfortable with religious expression personally, you see the reference there, but you don't think it's excessive. And again, that's where we come back to these two schools of thought, strict separation versus accommodation. A strict separationist tends to think all entanglement is excessive. An accommodationist tends to think no entanglement is excessive. Now, the Supreme Court realized right away that this test was an unworkable test. That is why just 2 terms after Lemon was handed down, within 3 years of handing it down, the court said in a subsequent case that Lemon was not a test. It was just a series of helpful guideposts. Well, I'll tell you, all the lower courts, you won't see a lower court that said, well, the Supreme Court said this is just a guidepost, it's not actually a test. They all adopted it as a test. They all tried to apply it as a test. And the court itself, in subsequent cases, would refer to it as a test and then would apply it as a test. And when it was being violated, they would invalidate whatever the government action was as a test. But the reference to helpful guideposts and signposts what was an indication that the court realized right away that this was going to cause problems. Now, the court, in fact, occasionally, an application of the Lemon test would lead to a result that a majority of the court found just so unacceptable that they would just unceremoniously set aside the Lemon test and just declare some sort of new test. In fact, one of those is what you heard of a couple weeks ago with Marsh v. Chambers, where the court 6-3 upheld invocations at the beginning of governmental bodies, legislative prayer, as it's called. And the court, in doing so, did not apply the Lemon test. They acknowledged they reasoned, they noted, that legislative prayer had existed since the Continental Congress in 1774. They also noted that in 1789, the very same week that the first Congress passed out the Bill of Rights and proposed it to the states for ratification, in that very same week, just a couple days later, they passed laws creating the offices of House Chaplain and Senate Chaplain, who would be salaried, who would be ordained clergymen who were paid a federal salary from the Treasury, whose foremost public duties would be to offer prayers at the beginning of each session of Congress. And so they just reasoned that the court, by the weekend, had not forgotten what they had passed on Tuesday, that Congress had not, and that therefore, whatever the Establishment Clause means, it can't mean that you're not allowed to have these prayers. And that was their reasoning in upholding legislative prayer. In that case, it was the Nebraska legislature. The court looked almost not at all to the facts in Nebraska. They looked back to Congress. They noted what Congress had done in 1789, and then they noted that legislative prayer had enjoyed ubiquitous and universal acceptance since that time at the federal, state, and local level. Therefore, it was not an Establishment Clause violation. Now, that was a 6-3 decision. There were 3 dissenters, Justices Brennan, Thurgood Marshall, and John Paul Stevens. And Brennan, in his dissent, said, the court today is not applying the Lemon test. I'll tell you why. Any group of law students, if given the facts of this case, would strike this down as an Establishment Clause violation under Lemon. And because the court's not willing to go there, that's the only reason we're not doing it. So I dissent. Ironically, Justice Brennan is correct in part. Legislative prayer does not survive the Lemon test. However, that is not because legislative prayer violates the Establishment Clause. It is instead because the Lemon test is wrong. And so when you're applying the wrong test, you might strike down something that does not in fact violate the Constitution. And Marsh was actually an excellent example of that. But nonetheless, so the court is dealing with Lemon. They're trying to find a way to salvage Lemon. Now, by the way, as it is putzing along, you're constantly getting concurring and dissenting opinions from justices calling upon the court to just overrule Lemon v. Kurtzman. Byron White did it. William Rehnquist did it. Scalia did it. Thomas did it. You know, people do it all the time. So, and everyone acknowledged that for the reasons I stated, the tripartite test from Lemon was just a mess. So the court tried to explore with different ways to try and salvage this test. Now, in 1984, the year after Marsh, in Lynch v. Donnelly, Justice Sandra Day O'Connor came up with her own pet theory about the meaning of the Establishment Clause, which is perfectly reasonable because Justice O'Connor, with all due respect, came up with all sorts of pet theories on all sorts of provisions and rights in the Constitution, including those that don't even exist, like abortion. And, developing the undue burden test for abortion, which Justice Scalia did a wonderful job of pointing out to say, which, of course, has no rooting in any area of constitutional law. What in the world is an undue burden? We'll just decide it case by case as things go ahead. But in 1984, in Lynch v. Donnelly, a case that was challenging a nativity display, a creche, Justice O'Connor floated the theory that the Establishment Clause is violated whenever it appears to be an endorsement of religion. Now, she voted at that time to actually uphold the nativity display at issue. There were also displays of Santa Claus, there were candy canes and stuff like that. And in fact, Lynch invented the infamous candy cane test, as it's called. Look to see how many candy canes there are and how close they are to the Christian thing to decide whether or not the Establishment Clause is being violated. Of course, the founders would be astounded at what they had wrought if you had told them that was the meaning of the Establishment Clause. But then in 1989, the court decided to actually adopt, by a single vote, adopt this endorsement test, which more thoroughly stated is that the effects prong of Lemon is violated. In other words, government action is advancing religion in violation of the Establishment Clause if a hypothetical reasonable observer, now hypothetical, this is not an actual human being, it is one that the judge is constructing. If a hypothetical, not just observer, but reasonable observer, would believe that government was endorsing religion. If the reasonable observer, who is explicitly allowed to understand and account for contextual facts, for history, for culture, for community tradition. He can factor all of those things into account. And if he decides that notwithstanding all of those contextualizing factors, the government is in fact endorsing religion, then it is advancing religion, then the Establishment Clause is violated. If, however, he thinks that in the course of all of these mitigating factors, if you will, that it's not actually endorsing religion, well then the Establishment Clause is not being violated. Now again, the endorsement test was an attempt to salvage the Lemon test. It was Lemon 2.0. Well, how well did it work? Well, you actually don't have to look further than that case. That case is County of Allegheny versus ACLU, Greater Pittsburgh Chapter. There was, excuse me, there was another nativity display, a creche, on the grand staircase of the county courthouse in Pittsburgh. And then there was a menorah outside the courthouse. The menorah was close to a Christmas tree. And the court concluded by a 5-4 vote that the nativity display was unconstitutional, but by a separate 6-3 vote that the menorah was okay. Now, you have to get into the breakdown more of that. There were 3 justices that wanted to strike down both of these, saying that they were both endorsements of religion. There were 2 justices, Sandra Day O'Connor and Harry Blackman, who was the author of the decision, who said, well, the menorah's okay, but the nativity display's got to go, because it's an endorsement of religion. And then you had 4 justices who said, no, they're both okay. And they're both okay because the endorsement test is not what the Establishment Clause requires. Now, those 4 dissenters were led by Justice Anthony Kennedy. And he was writing for himself and for Chief Justice Rehnquist and Justices Scalia and White. This is before Thomas was on the court. Thurgood Marshall was still on, and he was one of the votes to strike down both of them as unconstitutional. And then they, as Kennedy said, and this is, I think, what's correct, and this issue was presented to the court in Galloway, and we'll see if they take it or not, is that, as Kennedy said, that this whole endorsement concept, first of all, is just laden with a latent hostility towards religion. And that secondly, it's hopelessly subjective. I mean, how do you know what some sort of hypothetical person is going to feel? Because again, not a real person. It has to be a hypothetical person. What are they going to think or feel, and on what basis will those feelings arrive? When they're allowed to account for some things, the reality is that it appears that the hypothetical observer in every case tends to be aware of other facts, but it tends to be aware of some facts, but ignores other facts, and that all determines which way he comes out. Instead, Justice Kennedy said that the Establishment Clause is violated under what you could call a coercion test. The Establishment Clause is violated if government action touching upon religion coerces a person to engage in religion or religious activity against their conscience, or otherwise in a non-coercive fashion to do something that actually establishes an official religion. Now that second saving part needs to be fleshed out, because we all know what, or at least should know, what coercion looks like. But the last part there, that savings clause, is to say facts that are not inherently coercive but are just so extreme that you're just declaring a national religion. Now, an example would be, where do we look for that kind of stuff? Well, where do we look for every provision in the Bill of Rights? Where do we look? Where did the Bill of Rights come from? What were the framers of the Constitution looking to when they wrote the Bill of Rights? Go ahead. Anyone?
England?
Yes! They were looking at abuses they had experienced under the English government. Every provision in the Bill of Rights was written in response to what they thought were violations of their rights that were being perpetrated by the British. That's where we get the Fourth Amendment, where we get the Fifth Amendment, where we get the Eighth Amendment. Now, so what was an official establishment in the British system? Well, the British head of state is the head of the church. The king or queen of Britain appoints the Archbishop of Canterbury. He or she appoints the bishops of the church. Parliament passes acts where they adopt full-fledged creedal statements. This is what we believe happens during baptism. It washes away original sin, gives new life to the soul, etc., etc. This is what we believe about the Lord's Supper, because of course, you have the Catholic doctrine of transubstantiation, that the bread and wine actually become the body and blood of Christ. You have the Protestant conception that it's a memorial. You have the Lutheran conception of consubstantiation, which looks a lot like transubstantiation, but it's not. And so you have all these conflicting theories as to what's going on in communion. This is all being specified by acts of parliament as official national policy. That is what an actual establishment looks like. In fact, one of the best-selling books in world history is The Pilgrim's Progress. It was written by John Bunyan. Pilgrim's Progress was written by Bunyan when he was sitting in a British prison. He was there because he had been preaching without a government license. That's what establishment clause looks like. Now, being thrown in prison is also coercive. But that's where you're actually getting both parts of coercion. To have an actual national licensing system as to who's allowed to teach the things of God and who's not, according to these teachings, which are handed down by these bishops who are appointed by the king, and in accordance with the doctrinal statement that has been adopted by the national legislature, those are the aspects of an official establishment. And also imposing dedicated national taxes for the building of cathedrals, for the paying of the salaries of these clergy, etc. And of course, then when you come along to like a threat of being thrown in prison, that's when you get into the coercion aspect. That's what establishment looks like. It is not whether or not a small community wants to have a prayer before they begin their government meeting. It is also not whether or not someone wants to have a nativity display out on a lawn or in a courthouse. As long as, all right, so there's a nativity display in the courthouse. Well, as long as no one is making you bow before it, pray to it, or put money in a box beside it as you walk by, so long as that's not happening, it's not unconstitutional. No one's being coerced. And if you don't like it, look the other way. You can even give it the finger as you go by. I mean, I think that'd be rude, especially if there are children present, for crying out loud. Have mercy on the kids. But nonetheless, there's no consequence. If you do that, no one is going to stone you for blasphemy. So there's no establishment clause violation going on. Now, we'll get that in just a second. We'll get to, well, what do you do? How do you deal with this if you don't like it? So you have the endorsement test. Well, the endorsement test, which was designed to salvage Lenin, became just as big of a train wreck as the original letter. Because now, courts across the country would look at identical facts, and I mean identical. You would have Ten Commandments displays set up by the same organization in two different parts of the country, and it would split in opposite directions as to whether it was unconstitutional. The reality is, if you're dealing with more of a separationist judge, that's the Ten Commandments. This is, a hypothetical observer would definitely think this is an endorsement of religion. Then you get an accommodationist judge who says, well, it has a long and storied tradition in the American legal system, and, it's don't murder, don't steal, don't commit adultery. Those are all crimes, and, so that's implicit in our criminal law, and, there's nothing here that's an endorsement of religion. Now, sure, it is talking about, honor the Sabbath and a couple other things, but taken as a whole, it's good to have a day of rest. But taken as a whole, we don't think that's an endorsement of religion. Then you get, just 3 years later, so those were splitting right away. I mean, appeals courts were splitting all over on the Lemon test. On the endorsement variation of the Lemon test. Then in 1992, the court tried yet another spin on it because it didn't have 5 votes for endorsement. That was the case Lee versus Weissman, where there were benedictions being offered at high school graduation ceremonies for public school. Now, and this was hardly a Christian theocracy, it was actually a Jewish rabbi who was giving the prayer. So, I mean, we're talking about a minority faith here, not the majority faith. Nonetheless, the court, 5-4, held that it was unconstitutional. Now, not 5-4 as an endorsement, because the 5th vote in that case was Anthony Kennedy. And we all know from 3 years ago what he feels about the endorsement test. Instead, Justice Kennedy said that where children are present, where children are concerned, that there's a distinction between children and adults. that while we expect adults to have full-fledged opinions on what they believe on matters of faith or anything else, that children are young and impressionable, and that when we put them in the school setting, we are indoctrinating them that they should be compliant to the authority under them, and that if those authorities are engaging in a religious exercise, that the children are especially susceptible to having to adopt those beliefs, or in displays such as standing and bowing in prayer, that children could feel pressure, that peer pressure can be coercive for a child. If everyone else around them is standing and praying, that maybe they feel they have to do so, or they risk ridicule or social consequences. And so by a 5-4 vote, he said that prayers at school graduation ceremonies violates the Establishment Clause. Justice O'Connor couldn't help herself. She wrote a concurring opinion which she said, yes, this is unconstitutional because it's an endorsement of religion. She wouldn't let go of that. But it doesn't show up in the majority opinion because Kennedy doesn't believe it. You had a scathing dissent written by Justice Antonin Scalia, joined by Byron White, Rehnquist, and now Clarence Thomas, where Scalia largely just quotes back parts of Kennedy's Allegheny dissent from just 3 years ago and said, we said this, that's why that's not the case here. We said this, that's why that's not the case here. We said here, this does not violate the Establishment Clause. But that's exactly what we're doing right here. And so it was filled with his acerbic and almost angry tone when he gets really gets a full head of steam going in the dissent, where he basically said, this opinion is utterly irreconcilable with what the very same justice said this provision of the Constitution was about 3 years ago. And he's correct. But nonetheless, it's what Justice Kennedy said, so now it's the law, which is something you hear a lot these days. Now, but right after 1992, the court went back to the endorsement test because it no longer needed Kennedy's vote. Whenever Establishment Clause cases came along, it was a 5-4 decision. Kennedy thought nothing else was violating the Constitution, so he was always in dissent. O'Connor was the swing vote, and so we were back to the endorsement test each time. Now, in 1997, in Agostini v. Felton, the court then collapsed the entanglement prong into the effects prong, saying that whether or not something excessively entangles government and religion is just a factor in determining whether it advances religion, whether it's an endorsement of religion. And the court clarified just 5 years later, the court clarified that that's exactly what they had done in Agostini, is that they had reduced the Establishment Clause to a two-part inquiry. Then, in 2005, there were two Ten Commandments cases, McCreary County v. ACLU of Kentucky and Van Orden v. Perry. These were Ten Commandments displays, one in Kentucky, one in Texas. The court 5-4 struck down the Kentucky one as an endorsement of religion, but 5-4 upheld the Texas one. Now you had 4 justices who wanted to uphold them both. You had 4 justices who wanted to strike them both down as an endorsement of religion. The swing vote in the case was not Justice O'Connor. She said they were both endorsements of religion. The swing vote turned out to be Justice Stephen Breyer, who joined the endorsement opinion striking down the Kentucky display, but joined with the more conservative justices to uphold the Texas display. Now, the Texas display was 50 years old, and there were about 30 other monuments, many of which just of a patriotic or whatnot nature, out on the grounds of the grounds around the Texas State House. Whereas the Kentucky display was of recent vintage, and those who erected it had the legally ill-advised and probably legally unadvised course of action of issuing a bunch of statements about how they were doing this to put God back in his proper place in American society. So the court struck it down under the purpose prong of Lemon, struck down the Ten Commandments display as having a primarily religious purpose rather than a primarily secular purpose. Now again, you still had 4 votes to uphold it. But in doing so, the court in McCreary collapsed the purpose prong into into the endorsement test as well, where they said that that the reason a religious purpose, a primarily religious purpose, violates the Establishment Clause is because such a purpose could cause a hypothetical reasonable observer to believe that government was endorsing religion. So as of '05, the tripart test of Lemon had completely collapsed into a singular inquiry of whether the government was in fact endorsing religion. But again, you had 4 votes in McCreary dissenting, saying there's nothing wrong with this. Justice Kennedy was among those dissenters. Without him, there's no way you would get to 4. and then you have what in the world Van Orden means, because there was no majority opinion in Van Orden. So we have to look to the Marx Rule. Does anyone know the Marx Rule? Marx versus U.S., 1977. Yes.
I assume that's the things you find in all of the opinions, or the things that are shared by the various pluralities?
The Marx Rule, which is famously unclear, but that NYU grads may well have, a cause to use. You guys could be involved in some complex, advanced, sophisticated appellate litigation. This is not the kind of thing that typically comes up in district court. It doesn't typically come up in state court, but you can deal with it in federal appeals. When there is no majority opinion, there is no opinion of the court per se, the holding of the court shall be construed as the narrowest grounds that enjoy the assent of at least 5 justices. Typically, sometimes that'll be the plurality opinion. It will typically be a partial concurrence. And where you have 4 justices that go this far with kind of a broad rationale, and then a 5th justice that comes along saying, I'm not willing to go that far, I'm just willing to say this. Well, whatever this is, that becomes the holding of the court. That's what the lower courts must regard as a controlling precedent of the U.S. Supreme Court. Now, one of the ambiguities regarding the Marx Rule, this has nothing to do with the Establishment Clause, but it's good jurisprudence, and you guys need to know it. It's not going to be on the bar, but again, do you want to be an okay lawyer, or do you want to be a great lawyer? If the latter, listen up. One of the many ambiguities in the Marx Rule is whether it must be regarded as a precedent by the Supreme Court itself when it later reconsiders that issue. That is to say, must they regard stare decisis as an issue when they revisit a fractured court? Now, I'd say jurisprudentially, the answer should be no, because if there were not 5 justices, it was not a decision of the court. You're wanting to bind the lower courts, but when the high court itself takes it up again, if there was never a majority sentiment, the Supreme Court does everything with 5 votes out of 9. So if you didn't have 5 votes for a particular reason, it was never a reason of the court. And so if there is a clear majority later on to move in a different direction, that majority should not be constrained with what could have been just a single justice. In that, you could have 3 justices on this, 1 justice on that, 1 justice on that. That 5th justice happened to have the narrower opinion, so now it becomes the controlling rule of the court. Well, you don't want that to actually constrain what could be a unanimous decision by a later court. That earlier decision was fundamentally wrong, and the law needs to move in a different direction. But nonetheless, so everyone needs to figure out regarding the Marx Rule what exactly the rule is, because 4 justices in a plurality written by Rehnquist said that where passive displays are concerned, which obviously in that moment was speaking to Ten Commandments displays, but it would also apply to crosses, roadside crosses and whatnot, nativity displays, that where passive displays are concerned, it said, Lemon is not a helpful test. Lemon does not apply to passive displays. Well, you just had 4 votes to pretty much just jettison. Really, the Establishment Clause can only be, there's only 3 types of Establishment Clause cases. Passive displays, active messages, or governmental spending. Passive displays are what I just said. Active message would be something like legislative prayer. An actual verbal message, or it could be a written message of some sort, like "In God We Trust on Money" would be an example. And then again, where you have just government spending money on religious matters, which is where many of the more recent Establishment Clause cases have come from. And of course, then you have that narrow rule that we discussed, that ever narrower rule from Flass v. Cohen as to whether someone even has standing to litigate the case. But the court, in what accounts for perhaps half of Establishment Clause cases, passive displays, is saying that Lemon just doesn't apply. Well, and Justice Kennedy joined that in full. He joined Rehnquist's opinion. Well, what about the 5th vote? What did Justice Breyer do? Well, Justice Breyer wrote an opinion concurring in the judgment only. He joined no part of Rehnquist's opinion, so we have nothing that's a majority opinion. And Justice Breyer said that he believes that in certain borderline cases, no explication as to what borderline cases are, but just in borderline cases, he says, I believe there is no test-related substitute for the exercise of legal judgment. That has been called the legal judgment test. But it is quite literally no test at all. What the guy said was that in a hard case, I don't think there is a test. I think the judge just has to use good judgment. Now, he has to use legal judgment, but fortunately it's a court of law and he's a judge, so whatever he says is going to be a legal judgment. So whatever he says will be an exercise of legal judgment. This becomes just when you thought nothing could get more subjective than the endorsement test. You find out there is something more subjective. It is called the legal judgment test, where the judge just says, this is an awful hard case, so I know an Establishment Clause violation when I see it. I will declare whether or not this violates the Establishment Clause. I will not articulate a test that leads me to that result. I'll just say I'm exercising legal judgment. Or rather than I'm exercising judgment, this happens to be a legal case, therefore it's a legal judgment, therefore I'm right. Well, the legal judgment test hasn't necessarily caught on for obvious reasons. There's nothing there. But nonetheless, it was the fifth vote in a recent Supreme Court case, so under the Marx rule, it is supposed to have some force of law. Ironically, though, there would be only one aspect that seems to satisfy the Marx criteria, and that is that the Lemon test should not apply to any sort of passive displays. You have four of them who say it explicitly, and then you have Justice Breyer saying that, well, yeah, it doesn't apply to this Ten Commandments display. So you have 5 votes. You do have overlap. You have 5 justices who say that the Lemon test should not apply to passive displays. Well, this might not be a surprise to you. Ever since those cases were handed down in 2005, Ten Commandments cases, Ten Commandments displays and crosses and whatnot continue to be mowed down in the federal courts. Some courts, lower federal courts, continue to apply the endorsement test. Some apply the legal judgment test. And they just say that in their legal judgment, this is an Establishment Clause violation. The Ninth Circuit said it had no idea to determine which test applied, so it applied both tests and struck down a war memorial under both tests, both because it is an endorsement of religion and in their legal judgment it's unconstitutional. So they just covered their bases. That is the Mount Soledad Veterans Memorial, which is now still in litigation. So everyone has been hoping that, as one Sixth Circuit judge said, that the Establishment Clause remains, that the courts remain in Establishment Clause purgatory. And we're hoping that we would be liberated one day from this. In Town of Greece versus Galloway, which I'll conclude without going into that because you had a speaker who did it just a couple weeks ago. It was the lower court in that case, the Second Circuit, struck down the prayer practice in the town of Greece, New York, which is here in this state. It's Western New York. Struck it down as an endorsement of Christianity. Now you have to understand, maybe you guys weren't there. The practice in the town of Greece is that every house of worship in the town directory is given an invitation that they can volunteer to give someone to offer prayers. But understanding that some people may be part of minority faiths without a house of worship, or that they might have a spirituality which is not part of an organized religion. To make sure no one's being excluded, the town policy is that any town citizen any town resident can volunteer to pray. And over time, despite the fact that in this town, which is over 90% professing Christian, not surprisingly, every house of worship in town limits happens to call itself Christian. But they have, over time, had others take advantage of this. There was a Jewish person who prayed. There was a follower of the Baha'i faith. If you don't know what Baha'i is, I'll explain it later. And there was even a Wiccan priestess, a witch, who offered prayers to Athena and Apollo. She was allowed to pray. They even had an atheist sign up to pray. Now, thankfully, he withdrew at the last minute and spared everyone an awkward moment. I don't know what he would have said. And in fact, I've always said thankfully, but now the more I think about it, I'm not sure I am thankful that he withdrew, because now I'm left wondering every time what in the world the guy was going to say. And I think that was the attitude of the town, too. It was, We don't know why you want to pray. Who are you praying to? But you're a town resident, so they let him sign up. The bottom line is everyone could sign up. Everyone could be part of this. Nonetheless, two militant secularists in town filed a lawsuit. One an atheist, one a Jewish person, filed a lawsuit. The Western District sided with the town. It did so with a "you've got to be kidding me" opinion, where it's like, they allowed the Wiccan priestess to pray to Apollo and Athena. It's what more do you want from these people? And they made it clear throughout their pleadings. The plaintiffs made it clear that Marsh was wrong and should be overruled. That's what they were arguing, but lower courts can't make that decision, so they were just trying to carve out something. The Second Circuit reversed in an opinion by Judge Guido Calabrese, who holds court in this very city, in fact, where he said, well, you must look to the totality of these circumstances. Always a dangerous phrase in the law. You must look to the totality of the circumstances to determine whether the Establishment Clause is being violated, whether someone would think there's an endorsement of religion. He specified three things, but made it clear that this list was not exclusive. First of all, that a majority of prayers included what he called sectarian Christian content. Sectarian can sound a bit pejorative. He means faith-specific content. Second, that a majority of the prayer givers were Christian. Now, again, the town is almost 95% professing Christian. The prayer givers were much less than that, still over 80%, but still, the prayer giver portfolio was more diverse than the town population itself. And third, he found problematic that many prayer givers would say we or us, that they would use first-person plural pronouns when they prayed. Let us pray. Lord, we ask, things like that. My goodness, that means everyone in the town has to believe that. That looks like an endorsement of religion. But again, he made it clear that even without these things, you have to look at the totality of the circumstances, so just because you fix these three things doesn't mean I still won't strike it down as unconstitutional. Now, this created a scenario where really there was, out of random volunteers in a Christian-dominated population, there was simply no way you were going to prevent those things from happening without government getting involved in dictating who can pray and what they can say. Now you are flying squarely in the face of Levi Weissman, where in striking down the rabbi's prayers, the court said that it can never be the business of government officials to compose prayers for the people, to decide what can and cannot be said in a prayer. And in fact, Justice Souter wrote in a separate opinion where he said, I can't imagine anything to which courts would be, worse suited, ill prepared than to start determining what sort of content is acceptable in a prayer versus unacceptable. Nonetheless, that's the opinion that is still the law here in the Second Amendment. I mean, there's been a stay on it, but that is the law right here where we sit. The court mercifully took up this issue in Town of Greece versus Galloway, and ironically, it's both sides. The guys who won in the lower court have totally abandoned the endorsement concept. Their whole brief now, they do not defend one word of the endorsement test regarding legislative prayer. Now they say the prayers in Greece are unconstitutional because they're coercion. And they just quote the Levi Weissman opinion and basically say that adults feel the same peer pressure that children feel. So to see other people around you offering prayers will make you feel intimidated, so that's coercion, so it violates the Establishment Clause. Now, ironically, they say, whenever you're hearing a prayer you don't agree with, that's an Establishment Clause violation. Now, it came up during oral argument because I was sitting right there in the front. I represent members of Congress, as I said, in this litigation. Now, in the cert stage brief, where we asked the court to take it, I took Congress's modern prayer practice, not back 200 years ago. I just took the prayers over the last 2 years in Congress, over 300 prayers, and applied them to Judge Calabrese's test. First of all, a majority of prayers, 51%, use explicit Christian references. Fortunately for me, 51% is a majority. 97% of the prayer givers are Christian. And same number, 97% of the prayer givers say we or us when they pray. So I said, so, either Congress has been violating the Establishment Clause for 2 centuries, or the Second Circuit is wrong. And since the Supreme Court itself in Marsh said that Congress's practice is the touchstone of what is acceptable for legislative prayer, this has to be wrong. And the court took that up. Now, on the merit stage, my whole merits brief was about why the endorsement test should be jettisoned in favor of Justice Kennedy's coercion test. That was also 15 pages in the opening brief, in the blue brief, the petitioner's brief, was spent on why the endorsement test is wrong and the coercion test is correct. Then the red brief comes up, that's the respondent's brief, where shockingly they just lead with coercion. They totally disavow. They totally disavow the endorsement test, at least when it comes to legislative prayer. Now, during oral argument, they're saying, well, the prayer is coercive if it's saying things you don't agree. And so Justice Alito jumps in, and he says, give me a prayer that Jews, Christians, Muslims, Buddhists, and Hindus will all agree with. And then Chief Justice Roberts jumps in today, he says, and atheists. And then Scalia comes in, both hands going, he says, yes, throw the atheists in there too, give me a prayer for the atheists. Now, obviously, the lawyer for the respondents, Professor Doug Laycock, readily disavowed the notion that there was any prayer that would be something that an atheist would agree. He totally threw the atheist under the bus, which is ironic because one of his clients here is an atheist. Now, he was brought on at the cert stage. It was Americans United for Separation of Church and State that handled this in both of the lower courts. Then they bring in this big religion clauses professor from UEA, I didn't care much for his argument or his tone during argument. He sounded like a professor teaching students. The tone you want to have as an advocate before the Supreme Court is you want to sound like an associate to a partner in a law firm. There should be a collegiality, but one that recognizes that you are the lower person in the totem pole. So you keep it respectful and formal, kind of old school 40 years ago in business where you would say Mr. So-and-so when you're addressing your boss, you wouldn't presume to call him first name. Kind of that feel, but still, we're all working for the same company, you're the higher ranking guy and I'm going to be respectful as I speak to you. And Laycock sounded like a professor. He sounded that way in Hosanna Tabor too. Now he happened to win that case 9-0. But I think he won it because the justices were horrified by the Obama administration's argument that there's no ministerial exception, that churches and synagogues have no exemption from federal employment laws regarding who they're going to hire or fire as teachers of the faith, where the Obama administration said that there is no ministerial exception to, federal government can tell churches who they can and cannot hire. Horrified. But nonetheless, so they lost that 9-0. He made the huge mistake of saying to one of the other people at counsel's table, hand me a copy of the record. And he sat there and must have spent what had to be 2 minutes flipping through the appendix, looking at these prayers. And you have this one where he said, I may get the page number wrong, where he said, oh, here we go, page 74A. Oh, no, wait, sorry, that ends in Christ's name. And then and I'm sitting there thinking, my goodness, either you have an answer ready for a question like that or you don't. If you don't leave us all staring at you, 250 people, including the 9 justices, just staring at you as you're flipping through, where you keep saying, well, there's plenty of them in here. And it's like, really, Doug? Well, if there's so many, why can't you find one? Because there is no such one. Especially since Buddhists, for example, are non-theistic. They don't believe in a personal God. So any prayer that references Heavenly Father, even references the Almighty, you're saying you've eliminated one group there. Hindus are also kind of like quasi-non-theistic, that there are many gods, but they're kind of like different manifestations of an impersonal existence. So you're running afoul of all that too. The bottom line was there was no such prayer, and it became painfully obvious as argument went on. So ironically, I would say there's at least 5 votes to say what I think the court could just decide Galloway and what they said in Marsh. And I never gave you the rule from Marsh. They said Lemon does not apply. They say instead, legislative prayer is constitutional so long as the prayer opportunity is not being exploited to proselytize one faith or to disparage other faiths. In other words, to say that the person speaking for government cannot say you should change to this religious faith or threatening damnation for non-believers. So long as those are not going on, the prayers are okay. That's what the court said. You could have the court in Galloway just say, we meant what we said in Marsh. The other side isn't even asking us to overrule Marsh anymore. I think, again, that was the heavyweights that came on when it went up to the Supreme Court. And just say, look, no one's proselytizing here, no one's evangelizing, and no one's threatening to damn non-believers, so this case is over. These prayers were okay. They could do that, or they could do what the rest of us asked, to say that This endorsement test is an insidious hydra that just keeps on popping up wherever the Establishment Clause goes. Even when the Supreme Court says, don't apply Lemon, the lower courts still apply it. They just apply the modern version of it. And that they will continue to do so until this ill-conceived concept of endorsement is uprooted by the roots and just explicitly abandoned. That Lemon v. Kurtzman and Allegheny should be overruled. There wasn't a single question about that during oral argument, so I don't know if the court's going to get there. I hope they will. It was fully briefed. And you get justices like Thomas, who doesn't speak during oral arguments generally, who says that he believes oral arguments is unnecessary, that it shouldn't be a gotcha verbal game going on for an hour. You take these very thoughtful, well-written, carefully edited arguments on both sides, and the court should just decide it based on that. That's just a different skill set and kind of unfair to just catch people in rapid-fire questions until they say something that they trip on. But nonetheless, it's I don't know, we'll have at least a couple votes to overrule Lemon. Scalia and Thomas have made it perfectly clear that whenever the Establishment Clause goes up, they are quick to say Lemon should be overruled. Justice Alito never said anything one way or the other. He could very well vote along those lines. The questions are, does Justice Kennedy still believe now what he believed in 1989? And does Justice Roberts believe, as probably the biggest proponent of stare decisis on the court, where they all believe in stare decisis, but they all draw the bar at a different place? He sets the highest bar of the 9 justices, in my opinion. Does he think that no matter how ill-advised the endorsement test and Lemon test was, that its stare decisis either requires continued adherence to it, or at least requires it not be overruled if there's any other way to decide the case, in which case he could say, this case begins and ends with Marsh. This is our rule for Marsh, so the case is over. We'll leave Lemon to another day. What's going to happen? I have no idea. I do have an idea that a majority of the court thinks that the plaintiffs have standing and that this is a justiciable case. In fact, there was no question or doubt from either party regarding standing. So I believe they are going to reach the merits, and then we'll see what happens. Will they overrule the endorsement test? Will they even overrule, generally speaking, the whole Lemon test? Well, let's pray that they do.
What would you say to someone who would come back at you and say, well, the nation was founded when everyone was more or less Christian. Now we have a pluralistic society with many faiths. And so the Establishment Clause would have to take that into account also.
Excellent question. I'm an originalist. For me, that's an easy one. The meaning of any provision of the Constitution doesn't change over time. That's why we have a written Constitution. In fact, that is precisely the reason we have a written Constitution. We have the oldest written Constitution in the world. That, of course, means, well, it doesn't of course mean, but it does mean we have the first written Constitution in world history. Why is it written? Well, because the Founding Fathers were not anarchists. They said that they were declaring independence because they had rights as Englishmen. They had constitutional rights that were being violated by Parliament and the Crown, and that repeated train of violations rendered the British government illegitimate, that it no longer had rightful authority over them. Well, what constitutional rights were they referring to? Well, there was an English constitution. That constitution was not found in any one place. It was derived from various sources, from the Magna Carta of 1215, from the English Bill of Rights of 1688, coming off the Glorious Revolution, from various famous acts of Parliament, famous royal decrees, and from certain seminal political works, such as those by John Locke, or Berkeley, or Montesquieu. And the idea was, if you take all of these together and put them in a blender, that you could distill from them certain principles of limits upon government, and that those limits were the rights of the English Constitution. And the framers were saying, our rights, we have these rights, and they're being violated. The British never denied that there were constitutional rights. They just said, well, what we're doing are not violating those rights. And so the framers said, remember when I said every provision of the Bill of Rights was written as a pushback to an abuse by the British? That's also the fact that we wrote down the Constitution was a pushback against the British. The founders said, well, since we seem to disagree about what the Constitution says, we're going to write it down. so that everyone will know what it says and what it does not say. Now, we can disagree over the definitions of words, but we have radically narrowed the inquiry at that point. We know exactly what the words are. Now we just have to figure out precisely what their meaning is. That is why we have a written constitution at all. And so, as such, I'm an originalist. We live in a democratic republic. The Constitution is not some trick way for you guys to get around democracy and dictate to people what their government can do or what their rights are. It is designed, the Constitution is designed to make lawyers and judges servants of the law, not people who use it as a tool to accomplish their own agenda. The default in this land is democracy. And this gets into stuff like the gay marriage debate, for example. The Constitution is not primarily about equality or justice or fairness. The Constitution is about limiting government. It's limited in the powers it gives government, and it is limited in those few matters, those few rights that it declares so fundamental that it is removed from democracy, that people can't even, you're not allowed to vote on it anymore. Whenever you constitutionalize a right, you are terminating democracy on that subject matter. And the people are no longer able to express themselves and vent themselves and try to achieve their will through the ballot box, or at least, if they lose the election, have the satisfaction that they tried. Instead, you're getting someone who's never elected, never accountable to anyone, who is decreeing how things are going to be in their life, and they're not allowed to say anything about it. There is, in a democratic republic, there is only one thing that makes such an anti-democratic action legitimate. And that is if the people themselves have enshrined that matter in the supreme law of the land. The default is representative government, and we do that through the ballot box. The Constitution, every provision in the Constitution, it wasn't handed down by judges and it didn't fall from the sky. Every provision in the Constitution was adopted by the American people. And it was done so through a very rigorous supermajoritarian process. So it all comes back to the people, and it all comes back to democracy. It's just when you're talking about judicial review, you're talking about a supermajoritarian democratic process trumping a majoritarian democratic process. There is no role in that for people who think they're smarter than everyone else and have some sort of enlightened moral superiority, such that the unwashed masses are too stupid to live their lives and we have to dictate to them how it's going to be. Well, you know what? That is exactly the process that we broke away from when we declared independence. So it is the inherent truth in democracy is that people are free to live their own lives subject only to the constraints of the democratic process, which we do through representative government, and those few matters that we have actually put through this rigorous process to put in the supreme law of the land. It is never for judges to decide. So what does the Establishment Clause mean? It means precisely what it meant in 1791 when the American people ratified it, because that was the last time they spoke about it. And if judges don't like it, too bad. If you all don't like it, too bad. Then amend the Constitution. Neat thing about the Constitution is you can amend it any time. If you think there should be a wall of separation between church and state, or if there should be some strictly secular public square, then make it so. Start a constitutional amendment and then get it enacted. You can do that. You can do it if a solid majority of the American people support you and believe it's important enough. If you don't, then it's illegitimate for you to try and interfere with the product of the democratic process. If someone has a prayer before a town meeting, or if someone sets up a nativity display, how did it get there? It didn't spontaneously appear. It was either put there or said, depending if we're talking about displays or prayer. It either came from an elected official, or it came from some bureaucrat who works for elected officials. Either way you look at it, the people here are actually dictating this. If you don't think there should be prayers at your town board meeting, then tell your town council to abolish the practice. Elected leaders tend to be responsive to their people. If they refuse to be responsive to you, then vote them out of office. Replace them with people who do share your priorities. If you don't have the votes to vote them out of office, then it means you don't represent the will of the people. If you don't have the votes to get either the current leadership to cave or to oust them with other people, then it means you don't have majority support behind you. And if you don't have majority support, the Establishment Clause does not give anyone a heckler's veto to remake the public square according to their liking. It's like any other aspect in democracy. You can have your say. You can persuade your other citizens to join you in that say. If you have majority sentiment, you can achieve your will. If you don't, you won't. I voted against Barack Obama twice. Guess what? He got elected twice. I'm not happy about that fact, but I accept the legitimacy of the election. I voted. Of course, we had terribly flawed Republican nominees, but that's in both elections, but that's a separate issue. I voted. I lost. This guy who I think is running the country off the rails with socialized medicine and a number of other things is the president. He won it fair and square. It's no different from whether you can have a nativity display in your town square. That's something left to the democratic process. Politicians tend to be politically correct. That's where we get the term. And they tend to be sensitive to the various faiths that are out there. No one wants to be portrayed as imposing things on other people. But again, that is something to be left to the democratic process. It only rises to the level of a constitutional violation, where you can have an unelected judge impose the will of the law. That only happens if a person is being coerced, or if, again, the government is doing something so extreme that it's actually creating a national religion. But those extreme things are not setting up a nativity display, or it's not having a prayer, or it's not allowing a Ten Commandments display, or it's not having roadside crosses, or crosses in Arlington Cemetery. Instead, it's that stuff we talked about in England. If the President of the United States ever starts appointing church leaders in the country, then you have an Establishment Clause violation. Great question. Yes, sir.
So, along the line of thought, couldn't you also say that the First Amendment, or the Establishment Clause at least, is a repudiation of the Test Act, which was in existence at the time, and probably very cognizant to the Founding Fathers, that they knew, do you know what the Test Act is or no?
I've actually heard of it. I've never studied it.
So the Test Act is basically this sort of provision in sort of the English system where, and it came as a part of the Glorious Revolution to sort of oust Catholics, which was basically like if you want to participate in the political process, you need to sort of profess your faith. Obviously we're not getting that in town of Greece where you have to actively say that you are praying.
I don't think that's part of it, and I thought that's where you were going. Yeah. That's what I was thinking the Test Act was, but I was wondering if I was missing some aspect of it. No, that's where the No Religious Test Clause comes from. Mm-hmm. So that was already in the original body of the Constitution.
Right.
So the question becomes, well, why would we need an Establishment Clause beyond that? Because I think that what you referenced was 100% remedied by the No Religious Test Clause. That no person can be required to have to, well, I mean, you know what the No Religious Test Clause is.
Right, and I'm just wondering, like, maybe could that be extended to this sort of public space where if you aren't in that room, and this is a small town where you're going to be in that room presenting your proposal to get a zoning law changed, right? And you have to be there. You want to put your best face forward because you want to present this, thing that you want to change. And you're there and you're not the one praying. Doesn't that single you out? Isn't that?
No, because in the town of Greece, the matters that you present publicly are actually done in a different type of meeting. It's not done where there is no invocation.
So what is that meeting for? What goes on at that particular meeting?
Oh, I haven't looked at the agenda. I think they go over the minutes from the previous meeting and all sorts of stuff. Also during the meetings, and one can follow right after the other, but under law, they are separate meetings, and they are held separately. And people come and go. I mean, I've had people in the room. I've actually talked to people who were there. People come and go through the whole meeting. No one sits there. It's not like the Supreme Court where everyone comes, they all sit down, everything is stone cold silent, and then you have these proceedings that happen in a very structured format, and boy, someone entering or leaving is going to stick out like a sore thumb. None of that happens. It is a milling room where people are coming and going through the whole process. And plenty of people come after the prayer, and they just casually walk in, and in a steady stream. So it's not like you have a bunch of people who stay out the door until right after the prayer is said, and then they come flooding in. It's something of a free-for-all. And that's now, not only that, but let's again look to Marshall v. Chambers. In the Nebraska legislature, the rules of the legislature was that every legislator must be present when the session is began, and the prayer did not happen after that. So Ernest Chambers, the plaintiff, routinely was sitting there under a prayer that he didn't want to be part of, He didn't want to stand and be part of it. And he said at the time how he felt pressured because his actions, his nonconformity was being noted by the others around him with whom he had to cut legislative deals if he was going to be successful as a legislator. So he was routinely singling himself out for unfavorable treatment. He would also say that even though the rules required him to be in his seat for the prayer, for the whole thing, including the prayer, he would routinely hang out in the lobby until after the prayer was said, and then would walk in late and sit down, again, bringing himself up. So, but the Supreme Court in March said that is not an Establishment Clause violation. It also would have been the case, wouldn't it, in 1789, when they created the Establishment Clause? You would have heard prayers being said that there were people there who didn't agree with it. There were deists. There were some deists in Congress, people who did not believe in a personal God, did not believe that he miraculously intervenes in human events. Yet you go read the prayers from those days. You had references to the resurrection of Jesus Christ, to the hope of eternal life. The Senate chaplain for several years would only read the Lord's Prayer, would lead Congress in the Lord's Prayer. The first House chaplain, who was an ordained Episcopal clergyman, would read all of his prayers from the English Book of Common Prayer. So now you're getting specifically British, Episcopalian, Anglican prayers, and those were the only ones offered. Plenty of people present who didn't believe in those things. Certainly if you were from the Baptist tradition, if you were from the Presbyterian tradition, if you were a Quaker, all of those faiths represented in the Congress, you would have heard things all the time in Episcopalian prayers that you didn't agree with. But that wasn't an Establishment Clause violation. It was just a recognition of the fact that there will always be some level of disagreement between people offering prayers, and that having to listen to a prayer you disagree with did not violate the Establishment Clause. That was the case in 1789 and in 1983, well, 1791 when it was ratified. So that's the case now, because the American people never chose to change the words of the Establishment Clause. Yes?
Thanks for your talk today.
Thank you.
I was curious what you thought about state constitutions and their role in all of this. Things like Blaine amendments and such. To what extent do you think state constitutions have leeway on placing additional restrictions or creating additional liberties among these types of questions?
I regard, first of all, I think Everson was wrong to incorporate the Establishment Clause to the states. I think it is the only provision of the Bill of Rights that by its text and history does not apply to the states. The danger at the time, everyone was concerned about this. They were creating an office of president, and they were concerned about that president becoming the head of the American church, just as the King of England was the head of the English church. And that was the only concern they had. They had the concern about an official establishment. They were concerned about a John Bunyan scenario, where Congress imposes national taxes for the building of churches, where the ministers in those churches would work for the government, where the president would appoint their leadership, and then Congress would enact statutes adopting like the doctrinal statements, and you could be punished by the government if you refuse to attend these services and refuse to give a tithe of your money to the government for use on these churches, or dared to preach anything that was contrary to the official national doctrine. Now, I say that in contradistinction to the other provisions of the Bill of Rights, which, as you read the ratification debates, well, the debates proposing the 14th Amendment in 1866, largely written by Congressman John Bingham of Ohio. If you look at the debates on Congress when they proposed the 14th Amendment, or the ratification debates up until its final adoption in 1868, that they were speaking about free speech rights, political rights. Ironically, they spoke about voting rights, but we passed a whole separate amendment to take care of it. The right they spoke most often about was the Second Amendment. The one that was most frequently referenced was that the newly freed blacks, people newly recognized as citizens and free people, black Americans, were not only they were being victimized by systematic violence, and not only were there in the Deep South, not only were the local governments not defending them, physically protecting them, often it would be local law enforcement who were involved with the perpetrators to actually engage in lynchings and burnings and other lawless measures. So the issue was that that our black citizens in the South need to have the access to the means to be able to protect themselves and their families against the depredations of others, even including sometimes their own government. Which ironically, since the Second Amendment, the foremost reason of the Second Amendment was an anti-tyranny rationale to enable the people to hold the national government, the federal government, in check by the latent threat of the force of the use of the force of arms to overthrow a tyrannical regime. That very concern about being a check on federal government power in 1791 was a concern against state and local power in 1868. That's why the Second Amendment was incorporated. It's why most of the other provisions in the Bill of Rights are incorporated, though I agree with the decision not to incorporate the Seventh Amendment. Otherwise, every time you got a speeding ticket, you can demand a jury trial, because it's over $20. Seventh Amendment that you have the right in federal, right, if it's a federal issue and it's over $20, you can demand a jury trial. Have fun with it. But the Establishment Clause should not have been incorporated. Now, however, what is the only federal check on that? It's all about coercion. All 6 clauses in the First Amendment are about coercion. It's about your ability to think or believe, use whichever verb you choose. It's about your freedom to believe as you will and to express that belief. Free speech, free press, petitioning the government, assembly, or we have 2 special protections but the same principle regarding religion. The free exercise of religion is your freedom to be able to peacefully live out your faith, to express your faith and live it out without fear of government reprisal, which would be coercion. The Establishment Clause is the flip side of that, the mirror side of it. It is that government may not set aside your own private belief system, that government may not coerce you to involve yourself in the government's official religion. Now, as long as you have if there's a measure in the state that is actually interfering with your own personal exercise of religion, well, then I believe you would have a Supremacy Clause issue under the First Amendment. It's short of that. So long as government is not coercing anyone, or so long as government is not forcing you to be part of a state religion, I would say that that's where the line is drawn. Now, that might allow for all sorts of establishment-type actions, so long as they're non-coercive. That would not be permitted at the federal level. But not only can that be left to the democratic process, it was left to the democratic process. Because again, the last state establishment of religion was abolished decades before the 14th Amendment was even written. And more than a century before the Establishment Clause was applied to the states. So quite evidently, in terms of increasing religious diversity, the democratic process makes that happen. I mean, there could be some communities here in New York City that might choose to have a Jewish-dominated practice, whether it's in their legislative prayer or other matters. There's a couple suburbs like outside of Detroit where you might have the vote soon, if you don't have it now, to have a Muslim-dominated practice, like Dearborn, Michigan. I wouldn't be surprised if you had the votes there, or if it was close to having the votes, to have something like that there. There might be other municipalities, maybe like in San Francisco, for example, where they might choose to have no invocation. You might have a secularist or even a flat-out atheist or agnostic, dominated system. And if they choose not to have an invocation, I don't think an observant Christian there would be able to invoke the Establishment Clause to demand that they start praying, that they're having atheism imposed upon them from on high. So I think fundamentally it comes around to rights of conscience. And certainly if you read the briefs in Galloway, or if you read my brief for members of Congress, you'll see that was all the discussion on the House floor, on the congressional floor as they were proposing the Bill of Rights, as they were speaking about these provisions. It was that religious matters should be left to the conscience of every person, and that government should not be able to compel anyone to do anything that their conscience does not agree with.
I have 2 questions. One is, I know you might have hinted at your answer, but do you personally agree with Justice Kennedy when he said that children are impressionable and that a public display of whatever religion would violate the Establishment Clause? And also second, you said you would hint about this too. What do you think would be the immediate future of law and religion after the recent Senate rule change?
Oh, goodness. Well, I think the nuclear option is on a completely different topic. Happy to talk about that. I've been involved in judicial confirmation fights for years. I don't think it has any direct bearing on religion. So let me address the first one first. And in fact, let me hold that until just the absolute last question, that second part of it, because that puts us by and large on a different planet. But your first question was, remind me of the first question. The second one caught my attention so much that I forgot.
Whether Kennedy's argument.
Oh, yes. No, I believe it's completely incorrect. Because I believe children are different, sure. But I don't see any social ill. I would be with Justice Scalia that the public good that is Epperson v. Arkansas should be overruled. That is just manifestly wrong to think that the original meaning of the Establishment Clause said that government could not prefer religious faith to irreligion. That's why I started by quoting or paraphrasing, virtually quoting Washington and Adams and Jefferson. The framers of the First Amendment believed that peaceful faith. Now, in their minds, it would have been the Christian faith. I think we would speak today in terms of the Judeo-Christian tradition. I wouldn't say all religions, because you will find actions that are sanctioned by certain religions around the world that would be regarded as manifestly evil by anyone in the Jewish or Christian tradition, and rejected as evil by the American people. Now, of course, whenever you say that, some people say you're bashing on Muslims. I'm absolutely not saying that, because there are plenty of Muslims who would also appall those things. But I mean, when you see,
or the Hindu practices.
True enough, absolutely, throwing a mother onto a burning pyre, to be consumed in flames with her husband, and that's the duty of the children to throw her on if she refuses to go willingly. Well, by my moral code, that's murder. But also, you find in the Middle East, there are mothers. This is inconceivable to me. As a father of four, I cannot it shocks the conscience. For me to think of this, but I mean, you get people who strap bombs on their children and then put them in the middle of a crowd and blow up their kids, for goodness sake. I think there is, I have trouble conceiving of something I regard as more inherently wicked and depraved than a child who willfully murders their own child as an instrumentality to kill other people. I mean, that's you're not even drawing a weapon and charging the crowd yourself there. You are to an absolute certainty murdering your own child. A child has no idea what's going on. Certainly not consenting. You're talking about a baby, for crying out loud, and it's your baby. I mean, certainly for the founders, as a matter of natural law, that would be that would be an abomination, and I would call it as such. And if someone wants to say that's making me critical of another religious faith, so be it. I'll flat out say it. If you're willing to blow up your child, you're evil, period. And this society will never tolerate it. It should never tolerate it. And those who do so should be punished as, for the depraved murderers that they are. Well, the filibuster. This was a naked power grab, and we'll conclude with this. It was a naked power grab. Over the long haul, it may turn out to be good for, depending on what happens next, it may be good for good government over the long haul. It's not short term. It was a naked power grab. There are we have a bicameral legislature. Now, of course, we all know that the House represents the people, the Senate is to represent the states. That's why we have the different whatever. And of course, the 17th Amendment creates the direct election of senators. That kind of muddies that a little. But still, at least, it's not proportional to population. So you still have a per-state representation going on in the Senate. But there are other ways that they were meant to be different as well. All tax bills needed to originate in the House because they were the chamber most closely responsive to the people. Now, the way the Senate gets around that these days is whenever they want to do a tax, they take an HR, a House bill that's not going anywhere in the Senate, and they pass an amendment to just gut every word in it and insert the tax provision, then they pass it and send it back to the House. But nonetheless, that's good enough for Justice Scalia. Not a majority of the court, incidentally. There was the Muniz Flores case from 1988, but that's a story for another day. There are provisions that are undisputably committed to the Senate. Confirmation of judges, ratification of treaties. I mean, you have the division that impeachment is only in the House and it's by majority, but removal from office for those who were impeached can only be done. Impeachment trials can only be done by the Senate, and it must be a 2/3 vote to remove someone from office. So you do get differences between the chambers. Very early on, it was always thought of in the original design that the House would be the more passionate of the two bodies, that they would better reflect the passions of the people, and that the Senate would be the more deliberative body. It would tend to be populated by elder statesmen, kind of the idea that cooler heads would prevail. There's a lot of new senators these days, and I believe now over half of them served in the House and have not been in the Senate very long. And so some of the actions that are happening these days, I've heard some older senators, some longer tenured senators commenting on it, where they said that the Senate is really becoming the House. And that defeats part of the purpose of having two separate houses anyways. And that's not a good thing for the Republic. Now the flip side is this. There was something intolerable going on, and it needed to change. This will sound blatantly partisan. I know this is a 501c3. Let me just say to everyone present and to the camera, I am not being partisan here. I am just describing historical fact. It is liberal Democrats who ruined the Senate confirmation process for federal judges. Now, there was an incident in the 1960s involving Abe Fortas, who was an associate justice on the group. He was nominated as chief to replace Earl Warren by LBJ in 1968. Warren wanted to hang on to power as long as he could and then have a flaming left president appoint his replacement. He was too clever by half. He didn't realize that the president's preferred replacement for him would turn out to have some serious financial irregularities that would actually drag things on. And by the time that matter was resolved, there was a new president named Richard Nixon, and he nominated Warren Burger. Now, I'm not actually a big fan of Chief Justice Burger, but I will say he was much more conservative than Chief Justice Warren. The fact that his name was Warren Burger is an unhappy coincidence because people can easily get, Earl Warren, Warren Burger, and then you talk about the Warren Court, and some people get confused as to who you're referring to. That has happened over time. For example, we have a 5-star rank in our military, General of the Army, or Fleet Admiral in the Navy, or General of the Air Force. The reason we call them General of it was to create a parallel to the rank of Field Marshal for the European armies that we were working with, because we would recognize parities in rank, and we wanted to have someone who was not automatically outranked by someone that they had, and the General-in-Chief here, George Marshall, was to be the first 5-star rank, and then someone noticed his rank and name would be Marshall, and people thought it sounded awkward and would be made fun of as a joke, and that's the whole reason we came up with the name that we did. So sometimes names like that's a bit of a digression, but it's just to say it's not isolated to the judiciary. Sometimes we have matters like that arise. I'm not sure it would have been too bad. Marshall, he was gone soon enough anyways, became Secretary of State, and, I think we would have gotten past it. Instead, we just have, this anomalous history that no one either cares about neither knows about nor cares about. So, the Abe Fortas was under a threat of filibuster because it turned out he had some shady financial dealings, and it came up during his confirmation hearings for Chief Justice. So, in my mind, now, per the Federalist Papers, the 3 reasons that the Senate is not a co-appointor of judges or anything else for that matter. The Senate confirmation role for principal officers or federal judges were to be confined to 3 things. It was to look to the education, experience, and integrity of the nominee. The way Hamilton put it, among other things, was to make sure that the president was not giving nominations to someone because of family connections, because they were part of his family, or because he owed him money. They wanted to single that out. If the president was in hoc to someone, he shouldn't be able to buy him off with a presidential appointment. But that was the limited role of the Senate. The president was to work his will in that regard. And the Senate was just to make sure in the modern iteration, like for a judge, well, does he have a legal education that makes him good enough for this job? Does his resume show that he has the experience to execute this job? And is this an honest, trustworthy person? That's where Abe Fortas ran into problems again. Now, if a person turns out to have moral problems that rise to a criminal nature, they can actually be impeached and removed from office. But that was kind of the entry barrier to actually get in. And so I think what happened with Fortas was legitimate. Now, I think there is a fourth criteria that you can fairly add, and that is fidelity to the Constitution. If you go back before the 1960s, or certainly before 1937, for 150 years, those in federal office would have been horrified at the idea that judges could just ignore the words in the Constitution. That they could see something and assign to it a meaning that the words cannot fairly bear. Right? That's not what those words mean. It's written in English, not in a foreign language, and we all have dictionaries, and we can quibble on definitions, but it's all within a narrow range. You cannot look at the Due Process Clause and say, oh, that means you have a right to abortion. Abortion is nowhere present in the concept of due process. You could say the same thing for gay marriage. But the Second Amendment, right to keep and bear arms. Yeah, the right to keep and bear arms, the right of the people to keep and bear arms shall not be infringed. I mean, I'd refer you all to the Heller opinion, where Justice Scalia spends 60 pages consulting all the dictionaries and going through all the floor discussions at the federal level proposing it and the state level ratifying it, where it was manifestly clear they were talking about people having guns. Now, the only question is, well, what about knives, or swords for that matter? What about bows and crossbows? I mean, those are the questions you get into where you can actually have scholarly discussion. But as to whether people were talking about, and people can talk about, well, what about machine guns? And what about, now you can rule out crazy stuff. In 1791, arms were different than ordnance. So there's no RPGs, no bazookas, no missiles, no bombs, no nukes. Anything with an explosive element was ordnance in 1791. That's different from arms. Also, the right to keep and bear arms presupposes an object, an arm, that an average adult, not some Superman, can pick up and carry over distances. The right to keep and bear presupposes it is something you can bear, not, a cannon, with solid projectiles, with a range of 5 miles, and you can't move it anywhere, but you can blow up a building with it from, half a city away. That's not part of the right to keep and bear arms. When you, how did we get on that? Oh yeah, goodness. So I think that implicit in that is the fourth limitation of fidelity to the Constitution. That people have to accept that judges are not legislators, that they are to be bound by the text of positive law where there is positive law. Now, where there is no positive law, sure, then you're in a common law realm. But my goodness, there are statutes for everything these days, and there are regs for everything. I mean, it is rare. Federal judges still have common law power, but common law, you only have the power to make law through decisional law, where there is no democratically enacted positive law. And there is a truckload of positive law out there these days. So I think in that environment, where you have 4 out of 9 justices who look at the Second Amendment and say it does not secure any sort of individual right to keep and bear arms, and then you get 2 years later to McDonald, and they take just the rote repetition test for fundamental rights and somehow say that doesn't apply to the Second Amendment either. I think at some point you cross the law, you cross the line to people who are just not, are not taking seriously the text that they are supposed to be bound by. Now, it was, so in this realm where the court starts inventing rights, starting with Griswold v. Connecticut in 1965, declaring, a right to privacy and whatnot, you get in 1986 the filibuster, well, I'm sorry, not the filibuster, the actual defeat in 87, between 86 and 87, of Robert Bork. you have the two most famous federal appeals judges among conservatives in the 1980s. And everyone knew they would be appointed to the Supreme Court, both on the D.C. Circuit, Antonin Scalia and Bob Bork. In fact, I heard Senator Ted Cruz tell a story where right before that first of those two vacancies happened, there was an event going on after Ed Meeks became Attorney General of the United States, and this is at the beginning of Reagan's second term, where Justice Scalia was arriving at, Judge Scalia at the time was arriving at a place where the AG was going to be. And you had the security detail from the Justice Department there, the advance team, waiting for the AG to arrive, and they were holding the elevator for him. And here Judge Scalia goes walking in, and these U.S. Marshals or FBI agents, I believe they were U.S. Marshals, are like, "Oh, I'm sorry, sir, we're holding this elevator for the Attorney General." So Scalia just busts past him, and as the doors are shutting, again, this is before Reagan has decided who to appoint. As the doors are shutting, he says, "You tell Ed Meeks that Bob Bork doesn't wait for anyone." That's really supposed to be funny. He was trying to sabotage Bork. Anyways, all right. So some people got the joke. So Scalia was nominated, and he was confirmed 98-0. He was an outspoken conservative as a law professor and as a judge. Everyone knew where Scalia was coming from. But everyone knew, all right, Harvard Law Review, top student, a wonderful resume, judge on the D.C. Circuit, and pure as the driven snow in his personal dealings. There was no question that he was qualified for the Supreme Court, and so he was confirmed 98-0. It wasn't because there weren't plenty of liberals in the U.S. Senate at the time who couldn't stand everything Scalia said. But it was, in fact, Senator Pat Leahy, one of those liberal Democrats, said Justice Scalia's philosophy is not my philosophy, but it is Ronald Reagan's philosophy, and I have to respect the mandate that the American people have given the president. That was the traditional understanding. Then in the 86 election, Democrats took control of the U.S. Senate. The next vacancy that comes up, it was Bob Bork. Bork's resume is even better than Scalia's. Bork, top graduate from Chicago law, former Solicitor General of the United States. His work on antitrust is still the seminal work. Professor at Yale Law, one of their most distinguished professors. Had been acting Attorney General for a while. And then, too, was a judge on the U.S. Court of Appeals for the District of Columbia Circuit. Within hours of his nomination, Ted Kennedy took to the Senate floor, within hours, making one of the most appalling demagoguery political diatribes, I think an infamous speech in American political history, of Bob Bork's America, where he talked about Bob Bork's America, women will die in backseat abortions, African Americans will be forced to sit in a different part of the restaurant, police will be able to kick down your doors in the middle of the night, and just this absurd parade of horribles. Of course, the reality is if Roe v. Wade is overturned, as it should be, because it's a horribly illegitimate decision, abortion goes to the democratic process. I guarantee you New York is not going pro-life anytime soon. And if you happen to live in a state that does respect the life of the unborn, you'll only have to drive a few hours to find a state where you're going to be able to obtain an abortion. So, in my home state of Indiana, Illinois is not going pro-life anytime soon, and from any point in Indiana, you are not more than 2 hours away from Illinois. So even if everywhere else in the state it goes pro-life, everywhere else in the Midwest, they're still going to be able to go to Illinois and get an abortion. No woman is going to die in a back alley abortion. Nor are people, because of their skin color, going to be stuck in cells here. So they got whipped up into a frenzy and changed the rules. Those who voted against Bork voted against him because he was a known conservative, and they actually defeated him. Bork himself didn't help himself because everyone knew he was perfectly qualified, so when he was asked during his confirmation hearings for his views on various things, he answered the question. He gave long, elaborate, answers as to what his constitutional philosophy was and how it applied to various issues. Not issues that would be prejudged, but issues that were already out there. And then they used those words to hang them. Since the Bork hearing, no nominee tells you anything substantive about their views. You know, confirmation hearings are largely vacuous. Now, they didn't used to be considered even necessary. There were years where, what was the statistic? Most justices were confirmed within 19 days of nomination. If you go back a few decades, some of them were actually confirmed by the U.S. Senate, justices to the Supreme Court, confirmed without a confirmation hearing. You just look at their record and decide whether or not you were voting. After Bork, it became a showcase thing. Now, of course, after Bork went down. Then Ginsburg had some personal irregularities pertaining to marijuana. Ginsburg withdraws. Then we get Kennedy. Kennedy gets confirmed. And turns out to have a much different philosophy than people thought. He was called Bork without the beard by some people back then. That has turned out not to be true. And until he died, Judge Bork would frequently in speeches highlight the differences between him and Justice Kennedy on any number of issues. And Bob Bork did not mince words. Even if there was a room full of people or cameras were rolling. Then you had David Hackett Souter, who was believed to be conservative. Then you had Clarence Thomas, who was a known conservative, a clear conservative. Barely confirmed 52-48. That was 1991. 2 years later, 1993, Ruth Bader Ginsburg, the former head of litigation for the ACLU, known as an extreme liberal on matters of abortion and any number of other issues, also a tenured prof at Columbia Law, all sorts of published views, and then a long-standing judge on the D.C. Circuit. Confirmed 93-6. She was no more liberal than Scalia was conservative, or that Bork was conservative. Bork is more conservative than Scalia. Thomas and Bork are about the same point. They're both more conservative than Scalia. Ginsburg was not further from the 50-yard line on the other side than these guys were, in terms of what people call moderate. 93-9, because no one could deny her qualifications. Next year, Stephen Breyer, not near as liberal as Ruth Bader Ginsburg, but still a solid, known liberal. Again, a tenured prof, well-published views, and a long-standing judge. Confirmed 98-9. Overwhelming confirmation votes. Then we have nothing that goes on. You have John Roberts. You have some people who decide not to fight Roberts because they want to focus their firepower on the second seat, and they did that with Samuel Alito. Perfectly qualified, magnificent resume, et cetera, et cetera. Confirmed 58-42. And confirmed when the president's party held 55 seats. With a 55-45 Senate, he's confirmed 58-42. That basically qualifies as being barely confirmed, because it was largely a party line vote. Almost every Democrat was voted against. How the heck did we get there? And as a result, there are people, excellent people, who are not being considered for the court, because it's just their views were known. And it became a selling point if no one knew what your views were, or suspected but couldn't prove it. There wasn't a paper trail. But as if they hadn't ruined things enough in terms of what they did to the Supreme Court, in 2001, the Democrats started doing it for the first time with circuit court nominees. Now we're not even talking about the Supreme Court. Now we're just extending it lower. And I think they would have done district court, except that they know everyone can appeal to the circuit court. So, why consume yourself with 800 district court judgeships when you can just focus on 179, to be precise, federal appeals court clerkships. In 2001, led reportedly by New York's own Senator Chuck Schumer, who persuaded a critical mass of Democrats to go along with him, and then secured the approval of the then Democratic leader, Tom Daschle, to just start. Now, in that case, it was a pocket filibuster for the first 2 years because they had a majority in the Senate, just barely. And so they just wouldn't bring things up to a vote. So you never had a filibuster because it just didn't come to a vote. But then when Republicans took the Senate in 2002, it became a real filibuster. A minority of senators would just block votes. And the first one was Miguel Estrada, a former assistant solicitor general, Harvard Law grad who clerked for Justice Kennedy, had argued, I don't know how many cases before the court, but a good number. And memos came up that he was being obstructed because he was Hispanic. And I remember seeing the memo. I've quoted it in one of my books from Dick Durbin, senator from Illinois, who said it looks like this man is being groomed for the Supreme Court. And so they decided, we'll kill him in the cradle. That's a political phrase. It's not literal homicide. There's video it means to get someone while they're further down on the ladder. Where Miguel Estrada was denied, despite clear majority support. He couldn't have, they wouldn't allow a final vote to come up. That happened with various other judges as well, James Rogers Brown, who was a justice on the California Supreme Court, various other nominees. In 2005, after Republicans increased their majority to 55 seats, that broke the logjam, and Democrats agreed. Some of them agreed to what was called the Gang of 14 deal. 7 Democrats joined with 7 Republicans to agree we're going to allow certain people to go through, but not others. Then they allowed a final vote on those that they were allowing, such as James Rogers Brown. And the issue seemed to largely go away for a while. There were still plenty of nominees that were blocked during those years. Peter Keisler, another Kennedy clerk, fantastically qualified, was nominated for the D.C. Circuit, was filibustered for 2 years. And then Bush was out of office. Well, then Democrats took the Senate, and they were still not going to allow a vote. Then Bush was out of office. President Obama took office, who had, during his 4 short years in the Senate, had participated in these filibusters. If there's one thing the American people tend to get nuts about, it's hypocrisy. You know, when you yourself were one of the senators filibustering judicial nominees because you said you don't like their views, it seems a bit the pot calling the kettle black to say that you demand an up or down vote on your nominees if someone else wants to oppose them because of their views. And that's what changed with Harry Reid. And with what happened and I'll conclude on this, with what the Senate Democrats did last week. They threw out 200 years of practice that there were just places you didn't go. Now, one of the ones who opposed that move was Carl Levin, who is an unabashed liberal, but said that he was concerned that if they're doing this for judicial nominees now and executive branch, that soon it'll be done for legislation. And that he thought the filibuster was a critical rule, a defining rule of the Senate, which was of the utmost necessity for the U.S. Senate to have regarding matters of legislation. And so that's why he was voting against it, because he didn't see how you were going to draw the line. Now, Harry Reid promises they've drawn the line. In fact, they say it doesn't apply to the Supreme Court. It only applies to lower court nominees and executive branch nominees. I'm cynical enough to think that's because Democrats don't expect another Supreme Court vacancy. Ruth Bader Ginsburg has announced that she wants to hold on, that she believes the next president will be a liberal Democrat who will appoint a replacement that she would agree with, and she plans on keep doing what she's doing. And, you know, she holds a lifetime position. That's her prerogative. The left is going nuts. They think she should step down. I think that probably makes her feel like can make a person feel like a piece of meat, that people are trying to time your retirement. You know, it's like kind of macabre. You're looking at someone's possible death at some point and just trying to play the odds off it and whatnot. I don't think I'd like that. But nonetheless, that I think that's the only place where the only reason they've made an exception for Supreme Court nominees is because they don't think it's going to be a scenario they're going to deal with. If there is an unexpected vacancy, I expect them with a snap of the fingers to say, oh no, actually, there shouldn't be filibusters at the Supreme Court either. But this is a new precedent. I believe that if Republicans retake the Senate, which is becoming increasingly likely, I don't know how likely it is, but the odds are better now than they were a week ago. And if Republicans retake the White House, which if Obamacare is as big of a train wreck as I think it'll be, continually worse, and a number of other issues, I think that's an increasing likelihood as well. If 4 years from now there's a Republican president and a Republican-controlled Senate, I think Republicans are totally justified in saying, you know, the Senate runs on precedent. This is now the rule. This is now the precedent. And it can be adhered to. I hope the filibuster endures for legislation. I think the Founding Fathers wanted government that was slow to move on legislative matters. And I think that that's one of the reasons we have the division between the chambers. But regarding, from a good government standpoint, only the president can appoint judges. And seats need to be filled. Now, ironically, the seats in the DC Circuit didn't need to be filled. I mean, there are overworked circuits versus the DC Circuit's caseload is much, much lighter, much lighter. And I supported the legislation from some Republicans in Congress to just reassign those seats to the most overworked circuits. And the president would still have the same number of nominees, they would just go to different courts. Courts that would have, that as a matter of caseload, had a greater need for much greater need for judges. But nonetheless, it's done now. I would expect that each of the DC Circuit nominees will come back up now. Republicans, I think, will consume a lot of time in debate because even when you invoke cloture, there's still 30 hours allowed for debate. Usually, as soon as cloture is invoked, you just surrender the time, move to a final vote, move on with your life. But I think Republicans may take a lot of that time now to highlight this issue, fill the airtime with it, and make the president's supporters own these nominees. A couple of them, one in particular, has made some extraordinary statements. I mean, like the Hosanna Tabor decision, the ministerial exception to federal employment laws. When that came down, that was a unanimous decision. That was a 9-0 decision. Ruth Bader Ginsburg voted for that decision, Elena Kagan was on that decision. Professor Nina Millard from Georgetown said that decision was a threat to the rule of law. So evidently she's, she's to the left of Ginsburg on this issue pertaining to religious liberty, which I wouldn't have known that was possible. But nonetheless, I think it's likely that she and the others will soon be on the DC Circuit, and of course we respect the legitimacy of that. But I think this was a game changer, and I think it is one. See, because liberal Democrats are the ones who broke this process at each step of the game, it's always been easier to get liberals confirmed than it has conservatives. I'm not sure that's going to be true anymore. I think if this is the new rule, and if there's a backlash against the liberal state over the next couple of years, as I believe there will be, then I think we could be just a few years away from, frankly, a court that would overturn Roe v. Wade, jettison the lemon test if it's not already the votes to jettison it, and any number of other issues. So I think those on the political left may rue the day that they pushed for this move, because they're the ones, I would say that 4 times out of 5, they were the beneficiaries of what they were doing. And on a level playing field now, I think they have won a battle that will cost them a war. And winning a battle that costs you a war is no victory. Thank you for having me.